We're back on the record on 2021 CR 4408. We have Judge Roberto Vasquez. You've been previously sworn, Judge, correct?
Correct.
You remain under the same oath. Mr. Goss, your witness.
Thank you, Your Honor. Judge Vasquez, last time you were here, we had discussed a little bit about the time that there was a dispute about the front door security. You remember that discussion?
Yes, I believe so.
And the DA's office, at the beginning of this punishment months ago, told the judge that what they were going to prove through you is that the defendant, or Michelle, ceased providing security, or she just stopped providing security in the front. And I believe that what you testified to was that it was Michelle who decided she was no longer going to provide security in the front. Is that true?
If you're speaking about the incident where the metal detector was removed from the front door, is that what we're talking about?
Well, partly. So that, I mean, that
Is it that day or that time frame?
that time frame.
Yes.
And you were trying to get a contract with a different security company. Do you remember that?
Well, there's a lot of moving parts there because I don't sign contracts. That's done between county commissioners and outside third vendors, and we were having issues constantly at the front door with security. So that's how those conversations started earlier in that year, because this was ongoing for months. That was a culmination. That removing of the metal detector was
Not responsive.
the removal of the metal detector was a culmination of a bunch of issues, of a lot of incidents.
Judge Vasquez, let me go back real quick.
Sure.
I didn't say that you did the contract.
What's that now?
I didn't say that you did the contract, that you were signing the contract. I said you were trying to seek one, you were in negotiations, and you were talking to the people who does the contracts. Trying to get Blue Armor, trying to get Blue Armor to do the security on the front.
I don't specifically recall myself speaking with Blue Armor. I remember speaking to Commissioner Paul Elizondo about that.
And that's my point.
Right.
That's my point.
As a matter of fact, I believe that the commissioners actually amended a contract to bring a third-party vendor in to the precinct 2.
Would you agree with me that the entire time that this was going on, that Michelle was trying to provide security and told you that she believed that she was the proper entity and the proper agency to provide security to the front?
I don't believe she was protecting me in any way, shape, or form. She
Did I
might.
ask if she was protecting you?
What's that now?
Did I ask if she was protecting you?
I think you had a compound question there. There were two questions.
Okay. What I said was, you agreed that Michelle, at this time, was trying and was attempting and was making it known to you that she felt that she should be the person providing security at the front.
No.
You do not agree with that?
The conversations that I had with her were all over the place. Many of them were nonsensical.
So,
As it came to security, and that's what was very frustrating as a judge.
do you have a question in front of you right now? You answer.
I believe so.
No.
Because this is ongoing. This is not just cherry pick one 10-minute frame over incidents that are happening over a year and a half.
I understand that you want to testify, but I have to put a question in front of you. You answer the last one, and then I'll put the next one in front of you, okay? And so let me clarify. You are testifying today that Michelle never made it known to you that she believed that she was the proper person to be providing security and objecting to you trying to get somebody else or being a part of negotiations to get somebody else to provide security. Are you saying that that never happened?
Again, that's a compound question. You're asking two different things. On the first,
Are you objecting?
I'm not objecting. What I'm trying to do is answer specifically what you're asking. But I want to make sure that we answer the first part and we answer the second part.
Okay, well, let's take the first part. Are you testifying here today that Michelle never, ever made it known to you that she believed she was the proper agency to provide security at the front?
No.
You're not testifying to that?
No.
Because she did make that known to you?
Yes.
Okay. So now the second part. Do you believe, or are you testifying here today, that after she made it known to you that she was the person refusing to provide security for the front?
I don't believe that your characterization of the events is correct. Like I said, she was all over the place from day to day. One day I provide security, that being the constable. One day they don't. One day they've got another responsibility. Another day they do something else. That's why it's very frustrating when you're sitting as the judge in the court with everybody coming in and day out, and you don't know who provides security and if your security is even a priority. As a matter of fact, I sent that in an email to the County Commissioner Elizondo and I believe the sheriff that I didn't believe that my safety was a priority in that building.
I understand that you have a personal belief, right? And so you can have this personal belief that I don't feel safe because I don't like this person and I don't think that they like me and I don't think they're going to protect me or whatever. That is a completely, you agree with me.
No, because it's not about liking her or not liking her. I don't have any, I don't feel anything about her. All I'm worried about is the court security, my security, the security of the people that come into the building.
I'll just take your word.
This is not about a personal animosity between myself and another elected official.
Okay, I'll take your words. You had an opinion that the way that security was being provided was not to your satisfaction. Would you agree with that?
Absolutely.
Okay, now let's start there. Now, you agree with me that that is a completely different proposition from she decided she was not going to provide security. You agree that those are two separate things?
Yeah, those are two different things, absolutely.
Right. And so, for instance, if I were to go to McDonald's and order a quarter pounder, there's a difference between saying, I don't like the way you cook this, and you're not giving me one at all. Right?
I don't go to McDonald's.
Okay. Wherever you go to eat your food.
Usually my kitchen.
Okay. Wherever you go to eat your food, you've never eaten out before.
No, I have.
Okay. So when you've eaten out, where do you go? How about that? Where do you go to eat out?
Oh, for burger?
Sure.
Gosh, I mean, probably Chester's.
Okay.
Probably on 14th.
When you go to Chester's, there's a difference between ordering a burger at Chester's and saying, I don't like what they made me, versus they didn't bring me a burger at all. You agree with that?
Yes.
Okay.
Mm-hmm.
So what the state has tried to present to the court was that she just stopped providing security. And so you're testifying now that that's not true. She
No,
was
I'm not.
providing security.
Not that day. When they removed that, that was a specific hardcore example of how my security was put in jeopardy.
And that
when
was-
that magnetometer, that metal detector was removed from the front door.
And
That is an absolute egregious security breach.
And that was happening after you were in negotiations, after the county was in negotiations, with Blue Armor to come in and provide security on that day, January 9th.
That was after those talks had been going on for about 6 or 7 months, I believe.
And she was informed, along with you, that Blue Armor would be there that day to provide security.
I believe so.
And so, what you're talking about,
Now, without refreshing my memory on the exact emails, dates, and times, because there's a lot of moving pieces there, I can't tell you definitively if Blue Armor came in that day or the day after, but there's no reason for the metal detector to be removed.
I understand.
That was our property. That was my property, the JP's property.
And so the sum total of your testimony is that, about that issue, was that on one day, the magnetometers were removed from the front, and they came back, I guess, later that same day. And that was your issue. That's the issue. It wasn't that she decided that she was no longer going to provide security.
That's the culmination of everything that was happening for months.
But that
I mean,
was not-
that's the cherry on top of the ice cream right
And so
there.
this is my point. But that decision was not made by her. She had repeatedly told you that she felt that she was the person who should provide security, not Blue Armor or any other private security company.
Amongst many other things, yes.
Okay. I'll ask the witness.
No questions.
May he be excused? May he be excused?
Yes, Your Honor.
Thank you, Judge. Proceed.
Will you need me the rest of the day?
No, we are not going to call you back.
Okay, thank you.
Thank you. Any other witnesses, defense?
No, Your Honor, that's right.
All right, both sides rest and close the punishment phase.
Yes, Your Honor, state rest and close.
Defense closed.
All right, I'm going to give you a brief recess so that you can get ready for your closing arguments. All of the evidence is here, correct? So I'll give you until 9:45 or so, and you each get 30 minutes.
I'm gonna go upstairs and get my clicker, and at 1:18 a.m.
Yes, thank you.
This.
That's the redaction of State's Exhibit 118.
There's no objection other than ones that we've already made as far as of course, let it in, as far as the redactions. I think that's what, the court let it in that form, so that's appropriate.
Did you find the reference? Oh, hang on. Let me try to. Was that part transcribed of the trial? Give me just a few minutes. Let's take a break and do that. we can just, attorneys, just clarify for the record, we admitted 118A as an apple, and 118 is marked but admitted only for purposes of the appellate record, correct? Mr. Salinas?
Yes, Judge. And the contents of 118 and 118A are a press conference that was given outside the old courthouse. State attempted to admit 118 in its entirety, which included the statements from Mark Garcia, and I think it was also Jeremy Minor, under the argument that those statements were made in the context of being employees of the constable at that time. Defense, from my memory, objected to that based on hearsay. The court sustained it on that, but allowed the statements from the defendant.
Yes, so you have the redacted version, which is 118A.
Yes, which is only statements from the defendant.
Right, so that is admitted.
And I believe we objected to it in its entirety, and so we're just, we're standing by our objections and not waiving those objections. But we understand culturally, 118A is my understanding that what was supposed to be admitted, which is just my client.
Yes, okay, so then with that 118 and 118A, for the purposes we have stated on the record, are admitted. And State, are you going to go first, or are you going to
No, Judge,
split your time?
I request to reserve my time for rebuttal for 30 minutes.
Okay, Mr. Goss?
May it please the court, opposing counsel.
What I've learned, I guess, in my time trying cases, especially with juries, is that, and I still believe this, that jurors want to do the right thing. But what they generally that's their goal. That's what they try to do. But I've also learned there's another motivation with jurors, and that is they do not want to be humiliated. And the humiliation I'm talking about is that they do not want to feel like they made a verdict or gave a verdict that where they didn't have all the facts. And we actually saw that in the voir dire of this case in the individual juror selection, where we had the juror who had worked with documents for AT&T. And she said that she sat on a trial and they found a person not guilty, and then they came back later and talked to her about how all this other stuff that the defendant had done. And she said that it demoralized her, and that she felt like she had been cheated, that she felt like she had been lied to. Now, she didn't end up making it on our jury, but it is interactions like that that I have had, and that I'm sure the court has had, because you had the one that I had just recently with that juror. But it is those types of interactions that that has shown me that it is vitally important that the jury does not feel like there are things that they are not being told, because it can affect their verdict. In this case, from the beginning, and I want to start, before we start with the punishment evidence and all that other stuff, I want to start with the trial. And throughout the trial, the state told the court, we cannot try this case, we cannot prove this case unless we bring in all of these other parts of the investigation. And we'll talk about it later in punishment, what that investigation and what those other parts actually were. But throughout the trial, there were those microaggressions with these witnesses, these asides. We had to object, I believe, 5 times or more, and ask the court to ask the jury to disregard because the state or their witness had elicited something that would show that there was other things out there that the jury wasn't finding out, weren't knowing about. And what I know, because I know that they do not want to be humiliated by finding out something terrible later on after they've given their verdict on the facts as they are presented, I know that those microaggressions add up and culminated in Ranger Freeman blatantly violating this court's order, blatantly telling the jury that Michelle had committed other crimes. And at that moment, that jury was lost to us. It was, because we could not get back, even instructions to disregard, we could not get it back. Now, The reason he did it, or the circumstances that caused that, started with this table. And it started with the state from the very beginning telling this court, we can't prove it without all this other stuff. And so we look at what Michelle was convicted of. And you're here to determine sentencing. And there will be another time to talk about and to litigate that. He's been found in contempt, but there will be further litigation about that issue. And about those microaggressions that add up to a thought, perhaps, that Michelle was not able to get a fair trial from this jury because of the actions of the state and the state's witnesses. But when we talk about punishment, when we talk about where we're at now, one of the main things that the court should consider is what is the action, what was she indicted for, what was she charged with, and what did the facts prove happened? She was convicted. I've made it clear that it is hard to separate the conviction from the malfeasance by the state's witness. But what was she convicted of? She was convicted of 2 counts. The first count was concealing a document. But in this case, in any case, in the court's experience or in the experience of the law, it is difficult to understand or to figure out how a person who is intentionally trying to hide a document, intentionally trying to hide and conceal and to take it away and to make sure that it doesn't exist, why they would make 7 copies of it. It's hard to understand why a person who has complete and total power over Susan Tristram would leave all these documents that are incriminating with her to be found, as the court heard from the evidence, to be found on Susan's desk in Susan's purple folder. So when looking at it in terms of punishment, what could have happened if Michelle was an evildoer and a bad actor and wanting to conceal all this malfeasance or all these crimes or all this whatever? What could have happened? Shredding, taking and burying, having it never see the light of day, right? And that's what you would expect. That's what you would expect in any kind of case where people are trying to not let anybody see this bad stuff that they're doing. You would expect that it would be taken away, that something would be done to it. And in that is where the punishment levels go. Because everything has to be taken into context. So the actions of Michelle, even if taken in light most favorable to the state, and if the conviction, assumed that the conviction wasn't tainted, she didn't even take that step of destroying it. Now, what was the second thing? That she created a document that was false, that lied, that it had false information on it, in order to try to effect an investigation. But what did the state have to say? They had to say, well, we don't even ever have any evidence that she tried to effect the investigation with it, that she actually gave it to anybody. So if you look at that count and you look at what you would typically expect in that situation, you would have a false document that is given to investigators in order to try to fool them. But you don't have that here. So at most, what you have, even in the light most favorable to them in that verdict, at the most what you have is hiding documents that were in plain sight, concealing documents in plain sight, and creating a false document that was never actually given to anybody to try to effect an investigation. And so, because of those things, that's what she was convicted of. And because of those things, that would be on the lower end of the scale. Now, what they are going to do, I'm sure, is that they are going to tell the court that she is a public servant. The court has to send a message about public servants. And I don't disagree with that. I mean, if she were a public servant and she were found guilty of embezzling $800,000 or $50,000 or $150,000 from her organization, that's exactly right. I mean, there does have to be an example set. But that's not the case here. Because what we found is throughout the trial, the state tried on different motives, tried on different reasons why she would do it, and it didn't fit. None of them fit. They never presented to the court or to this jury that she stole any money, that she profited, that she financially benefited whatsoever from this conduct that they're assuming. So what they're really coming down to is, and what we're talking about, is what I guess could be called a process crime. Like, she didn't give me the documents when I asked for them. I asked for them, and she didn't give them to me. But I'll remind the court that what we saw during the trial was that the subpoenas, and there could be disagreement, but for sure the first subpoena asked for security agreements, and they got them. That's what they got. The second, never in any of the subpoenas, and I'll remind the court, did they ever ask for these cash logs. That they are saying that is the crime. We asked for them, and she didn't give them to us. But they never asked for them. And when I brought the auditor up, to enter in those documents that we talked about, I did it for a reason, and it's because. Do you mind if I approach your bench?
Sure.
It's because in Defendant's Exhibit 42, I'll show the court. This is from March 21st of 2018. In that exhibit, what the auditors were asking for was cash logs. This is in March of 2018. This is their exhibit that she was convicted of concealing from Bexar County. And that's the same. It's just that one has more filled in because after they turned it over to the auditor, Susan continued to fill it in. In Defendant's Exhibit 44, from May 9th of 2019, now this is after the Easter Rodriguez Park. After Rodriguez Park, to the Bexar County auditors, and I received this in a subpoena, this is their exhibit that she was convicted of concealing, and it's the same. And so what they have is they have that Michelle or her office, because she really wasn't doing it. You'll notice Susan Tristan's name's on it. But what Michelle was, when the auditor said we need the cash logs, they got cash logs. Now, this is interesting. In 40, this is a cash log. I get to use this Christmas tree here. This is a cash log that's not even included in any of the state's evidence for the cash logs that was found in Susan Tristan's possession. And I pointed out to say, if you took the state, because from this very beginning they had this idea that whatever Michelle does is wrong and we're going to find how it's wrong. So you could look at that and say, well, that's the evidence that Michelle took it and shredded the cash log. But it's not. When Susan Tristan testified, she testified that all of the cash logs that were found were all the ones that she had, which is not true, because that exhibit that you hold in your hand is an additional cash log. Now, at the time that that's going on, this is back in 2018, there is no, I guess, motive to conceal. Rodriguez Park hasn't happened. And I pointed out to say, perhaps, there wasn't this intent, this nefarious intent to conceal, this nefarious intent to hide some sort of crime that the state still has not put their finger on. And I'll point out, even in the punishment, Mr. Salinas is asking her sister-in-law about whether or not she just used cash to buy the lunch for the deputies. They're still, even at this late date, trying to find some sort of evidence, and they're reaching for something that they can show is a reason why she would do these things. Because they haven't. They had all the bank records. They didn't present anything that she has ever financially benefited from this. Now, going back to what they're going to argue to you, which is she's a public servant. But here's the thing. A public servant isn't above the law for sure. Michelle is evidence of that. She is living, sitting proof of that. But they are not below the law either. And what that means is just because they are there, the court still needs to take, it's not an axiom in our system that if you are a public servant, you go to prison if you're convicted of wrongdoing. The wrongdoing has to match, and the punishment has to match what she's convicted of. And it goes back to this fact that she has been convicted of concealing documents that were not concealed. They are arguing that they were not turned over to the DA's office. They were turned over to the auditor's office. And in fact, if the DA's wanted it, they could have gone to their own agency, their own auditor, and got the cash logs that they ended up presenting in trial as evidence of her crime. Those were provided by her office. But she has been convicted of concealing documents that were not concealed. They were not in her office. They were not in some secret place. They were not anywhere else but in Susan Tristan's folder where they always were. There is no dispute that she had every opportunity to take those out, to do whatever she wanted to do with those if she felt like she needed to cover up her crime. Instead, she had 7 copies made of these terrible, terrible documents that she was afraid of. And as far as the writing, now their interpretation is I mean, they've said that it was false. I've never heard any evidence, and I still have not heard evidence about one false thing that's on this document. But I've heard that, oh, well, this document had something different than this one. You can assume, as the state wants you to, that she was trying to do this to somehow hide some crime that she had committed. But if you do that, they have to explain to you what's false. They have to explain to you something that shows a motive. Because if they don't, you can also believe that she was doing exactly what it looked like, which is, Susan, your records are not good. I'm trying to figure it out. And the reason why that makes more sense is because it stayed in Susan's folder where the other stuff did. It was never sent to an investigator to try to mess up an investigation. And when you look at that, and Mr. LaHood pointed that out, I mean, this is like a draft. It's got crossed out stuff. I mean, this wasn't intended ever to be anything other than personal notes about this garbage that Susan was doing. Now, she is the constable at the time. She's responsible. She's responsible for making sure Susan does the right thing. Nobody is arguing any different than that. But what we're saying is, we're talking about prison. We're talking about going to prison. That's what the state, I'm assuming, is going to ask you. Or to be incarcerated somehow as a condition of probation, and neither of those are appropriate, because when it comes down to where we look at what she was convicted of, that, even taken as if all of that were true, then the verdict was sound, which I do not believe, but I will take in an argument that it was true. Then, that is probably the lowest possible way that you could possibly commit that offense. Because even one step up would be taking the stupid things out of Susan's folder. I mean, one step up would be typing this thing up and trying to present it to an investigator, or doing something other than a bunch of squiggles and wiggles, and nothing was proved false on there. Susan Tristan was on the stand. She didn't say, "Oh, that's a false statement." All she said was she was trying to write it from memory. Right? Now, one of the things I didn't point out is that in 31-2-9, I should have. It's one of those things that I've had a lot of time to reflect on the trial that I regret. Because Susan was not telling the jury or the court the truth about that. Because if you look at 31-2-9, and then I'm looking on what we call the Christmas tree, that's 17-3, these are written out word for word. When it says a Castillo, it's a Castillo. When it says Castillo, it says Castillo. There's no way she's reproducing this from memory. She's sitting with Susan trying to figure out what this means, and if Susan has adequately and accurately recorded those things. Now, I'm not saying that there aren't maybe differences perhaps, because I don't know the conversation that Susan had at the time about, well, okay, I had this, but we also did this. I mean, you can see in some of these documents that at one point there's a receipt number written in after they give it to the auditor. So what it means is when they gave it to the auditor, Susan didn't have the receipt number. She came back and wrote in the receipt number. It's in her handwriting. So you can see some of the differences between. But this is word for word. This is exact. It's written exactly. Where it says void, it says void. Where it says this, it says this. And so Michelle wasn't sitting there trying to write it from memory. She was sitting with Susan, trying to figure out what was going on, because they had received a subpoena. All that is true. And she's trying to figure out, what are they asking for? What are we doing? What have you done with these records and these documents? That takes us to the punishment. The state at the beginning told you that they were going to prove that Michelle committed aggravated perjury, and they didn't. You know, I was trying to think of like what an example of it was, and it's kind of like if if Moreno said, I think SUVs are the best type of vehicle, and then Mark Garcia says, that's a lie. SUVs aren't the best type of vehicle. You've committed perjury. And then the DA's office says, that's a lie. It is not perjury to say that SUVs are the best type of vehicle. You've committed perjury. So ultimately, it's ridiculous. The affidavit that they have in evidence that Mark Garcia wrote, the statements that he made, are ridiculous. They're just opinions. It never should have been signed. A warrant like that never should have been signed by a judge. But there's a difference between perjury and being ridiculous. There's a difference between perjury and...
Well, I'm going to interrupt your closing, and I want you to walk me through your client's actions after this ridiculous warrant was signed.
I
I
understood.
want you to walk me through your client's actions
Sure.
by text message, by everything she did to distance herself from this wrongful arrest.
Well, here's where I'm going to get to, is that first of all, once Mark Garcia does it. Now, Mark Garcia is her captain.
Well,
Right.
hold on. Mark Garcia's testimony was excluded by the court and not considered. But I
understand.
can consider your client's actions after that.
I understand. And so,
Walk me through what the evidence is, her
So-
actions were.
right, so you look at Mark Garcia. So first of all, you have to understand what you have heard, the testimony that you have heard about who Mark Garcia was in this agency, right? He was her captain. He was somebody with authority. He was somebody who did his investigation, and Mr. James told you from the stand, I think quite credibly told you, that Mark Garcia was fixated on the investigation, did the investigation, was told like, hey, maybe don't do this, maybe do this, but said, I'm going to do whatever. I got this. I'm going to do it. Now, once that happened, and once he made the arrest, I'm not saying, and I'm not saying that Michelle herself wasn't believed that, that this is a false thing. Mark Garcia told her, and he obviously had confidence in his investigation, and she had confidence in her captain. And so, and here's
Well, misplaced.
absolutely misplaced.
That's your argument, that she had misplaced confidence in Mark Garcia.
Well, absolutely, but here's how you know just from the evidence that you have from the text messages. So what those text messages are showing, and I was pointing this out, I was talking to Jasmine about this yesterday. What those text messages show is that once Mark Garcia made his decision that he believed that he was right, she has sent Mr. James in, and he has said, look, I got this and everything else. But once that happened, what is she going to do? She is going to back her captain. She believed in him. She believed that what he did was right. But how do you know that? Because she didn't slink off like, oh my gosh, the DA's dismissed it and everything else. Those text messages show she's going back to the DA's saying, look, this is the evidence of perjury. This is the evidence of it. We have
You
it.
just call that evidence ridiculous.
It is ridiculous. I know it's ridiculous, and you know it, and they know it. She didn't. Nobody is saying that nobody's saying that she's a legal scholar. Nobody is saying that she is the paragon of law enforcement. I'm gonna say it. I'm not saying that she knows or that she knew that was wrong. Because to her and to Mark Garcia, I believe Mark Garcia believed he was right. He went in there and talked to a judge about it, and then the judge said, well, what about this and this and this, and he added those things. I believe that Mark Garcia was terribly wrong. I believe that the whole thing was a farce. It could have been stopped at the magistrate's office, and it wasn't. However, those text messages show that Michelle went back to the DA's and said, look, what's the problem here? What is the issue? And that should tell the court that she truly did believe in Mark Garcia. Whether or not it was the correct thing, I'm not saying that it was correct.
Even after Mr. James told her, give it to the DA, file it at large, we're going to get in trouble.
Mark Garcia made a decision. Mark Garcia made a decision not to.
And you're saying your client could not have distanced herself immediately from that decision, call it what it was, and say, I have no part in this?
She absolutely could, but
But she didn't.
because she believed in his investigation.
But she didn't, right?
She did not, but she believed in his investigation. But it's not perjury. I mean, that's ultimately the issue, and the DA's dismissed the cases because it's not perjury. I'm not saying that Michelle didn't make mistakes. We've never argued this. We've never argued that Michelle's just been perfect. But I do believe that the pitchforks have come out, and they came out for her because they don't like her. The commissioner's court, the DAs, the public, when they see her, when they play this press conference, or when they play this thing, the pitchforks are out because they feel like she needed to be knocked down a peg. And she has been. She has been humbled. She has been humiliated. She has now been convicted. But ultimately, no one is saying that the arrest of Moreno was a correct thing. Nobody is saying that. But there's a difference between maliciously trying to do this and mistakenly believing that, well, he's obviously not telling the truth. Because he didn't tell the truth. I mean, I think that even with the evidence that they've shown, that he didn't tell the truth about things. Now, you and I and everybody else who is in our system understands that that's not perjury. The magistrate judge should have understood that. Should have, but didn't. The reason we have the magistrate judge is because police officers often make incorrect decisions about what a crime has been committed. They do. We don't go and get them all for perjury. Even when they believe that incorrectly that a crime's been committed, we don't go, you're indicted now for perjury. We should have a magistrate there. That's why they're there, to say, we should have a DA's office there, right? And we do. But when it doesn't go to the DA's and it goes to the magistrate, that's the stop. And that part of the system failed. Because there will always be police officers who mistakenly believe that a crime has been committed. There will always be police officers. I worked as a magistrate prosecutor for 5 years. I told police officers every night, that's not it. You don't have it. That's ridiculous. I got a lot of pushback from them. I got them coming back with new reports. I got them doing all of those things that she did. I got them doing it, and I didn't for once assume that these people were malicious people. These officers were malicious. I knew that they were mistaken, and they felt that they knew more than I did. Now, yes, that's bad. That's wrong. It's not prison wrong. She's been convicted. She's going to be under the jurisdiction of this court. But the reason that they couldn't get perjury is because they couldn't prove perjury, and they didn't in the punishment. Additionally, and I'd ask for a little bit more time. I'm in 4 minutes. I'll probably need about 7 or 8 left. The official oppression and the unlawful arrest of Leo Moreno, we've talked about that. Subjecting Leo Moreno and Christopher De La Cerda to mistreatment. The evidence that you heard was not evidence that would rise to that level of official oppression in these counts. That was part of the problem of why it was so damaging during her trial in front of a jury, that they would still continue to try to bring that out after you heard what they were talking about. They were talking about being assigned bailiff and having to wear a shirt that said bailiff and security on it. That was their mistreatment. And nobody's saying that there wasn't dysfunction in that office. She had to hire back people that she had fired for provably lying. It's still on their T-call. Lied about their training. And she had to hire them back. And that's going to cause dysfunction. That's a part of our system. I think that's a problem. Because if you fire somebody, and it's not she didn't fire them wrongly. I mean, they got put back on, but it's T-call did their investigation, and that was shown and proven to the court. T-call did their investigation showing that they had lied, and everybody agrees to that. The false information to the ranger about the condition of her vehicle. The reason we introduced the thing is because it's just a confusion of words. She said the tire slashed. They said the tire's flat. But we introduced the recording to the court that showed that when they went and looked at the tire, they said they could see, oh yeah, there is like a slash there. It was not flat, but it was slashed. Now, it's a small thing, but it's only if you take everything in the light most damaging to her, which they have been more than willing to do throughout the trial, that the public has been more than willing to do, the media and everyone else has been more than willing to do. But when you look at it, we have presented evidence that there was a ranger looking at the tire and noticed a defect. And that's important because that's what she's talking about. So there's a defect on the tire. She never said, and they didn't present anything where she said, my tires were flat. The tire was flat. The ceased providing security. She wasn't intending to stop providing security. The reason I had Judge Vasquez was to say that there were some exchanges where she was saying, I am the person that should be doing it. And she was being prevented from doing it. And they went and sought a contract with a private security person and told her that that private security was going to be doing private security at the thing. Throughout the entire time, though, she consistently said, I am supposed to be the person doing this. Judge Vasquez didn't want her to do it. And that's a difference. There's a difference. If you don't want her to do it, that's one thing. But she wasn't trying to be derelict in her job. She was trying to do what she thought was her job, and she was being told that, no, I don't like the way you do it, and so we're going to have private security there. And so she said, fine. Now, the way you can go back and forth, and yes, I mean, should she be in pissing contests with Judge Vasquez? I mean, no. Could she have backed down? Yes. Could there have been a better way to work it? Yeah, but even with the way he testified, I don't know that. I think that there was blame on both sides there. We showed you the video of him screaming at her people. There was obviously some unprofessional conduct going on both sides of this equation. Now, the warrants and the releasing defendants with active warrants, there's a part of the law that says you can do it in these situations, but you can't do it in these situations. Again, I'm not saying that she is a legal scholar. It happened for a few months and then it stopped. And that was it. She went and talked to the DA. They went and had all this stuff, and then it stopped. Because that is more process issues. Like, so yeah, okay, you can do it here, but you can't do it here. The code is confusing. It took me a long time to read it just to understand when and where you could do it. And that will happen. I mean, that's going to happen throughout Bexar County. Constables and other law enforcement agencies are going to make wrong decisions about how to arrest, when to arrest, what to do, and blah, blah, blah. They get counseled on it, and then they change the behavior. The left the precinct 2 facility and its finances. I mean, we heard the evidence from Constable Vasquez that the credit cards were frozen by the commissioner's court after the commissioner's court wanted her gone. She was doing the best that she could, and it was frozen. She wasn't intending to leave the finances in such a way. She had no control over whether those credit cards were frozen. The commissioner's court did it at the time that they were trying to get her removed from office. And that's when the new constable came in. And so yes, there were some issues, but that can't reasonably be used as punishment. And finally, operated a guard company without a license. And I want to go back to the trial. Throughout the entire time, the prosecution's table asked you to let them talk about the fact that that was her motive. That was the motive that they tried to bring up. Please let us talk about it. And then they finally put a witness on there, and the guy said, I don't even know if it's a crime or not. I couldn't even tell you if she was doing that. Now, that leaves you two things. One, they already talked to him and they knew that when they talked to you. Or they didn't talk to him, or they didn't understand, or they wished it to be true. Because they're still looking for the motive for why this would happen. She's trying to conceal the fact she's operating a guard company without a license. But their own witness said, I don't even know that that's true. I'm not saying that they knew that wasn't true and was trying throughout the entire trial to get you to let them talk about it knowing that it wasn't true. But it really brings the point up that they wanted it to be. Because they want to find anything that they can find to explain what this is. They tried to do it and it failed. I mean, it failed miserably. And that's a part of how we look at all the actions during the trial. And I want to remind the court too that the court had the best, for the crime itself, for the conviction itself, the court had the best evidence that the court can have of what her mentality was as far as trying to hide things, as far as trying to intimidate Susan Tristan. And that was when they put a wire on Susan Tristan for 3 days. And they found not only did they not find anything incriminating, But when Susan Tristan was supposed to go over, and Michelle knew that she was talking to an investigator who had sent a subpoena, who were asking for the documents, that Michelle, if you believe Susan Tristan, Michelle knew that Susan Tristan knew everything if she were trying to do something wrong. Susan knew about this, Susan knew about these, and Michelle, sitting in a room with the others, when they said, go tell the truth, and she agreed. And then she came out and told Susan, and it's on the recording, you're going to be okay. It's okay, just go in and do it. That shows you, when you're trying to determine the proper punishment in her heart, that shows you that her heart was not in this place of like, of I want to conceal and hide and do whatever. Or on the wire, that she did not know was being recorded, she would have told Susan, like, do not tell them about any of this stuff that we did together. She didn't. And ultimately, when you're deciding her punishment and you're deciding who she is, she had every opportunity to be a bully in that situation. She had every opportunity to cause Susan harm or to threaten her or to do whatever, and she didn't. She agreed with the statement, go tell the truth, and then she said, it's going to be okay, just go and talk. That's it. Finally, the Dollar General. Now, that is obviously, and Mr. James said it, it's not right. You know, and she would agree with that. I mean, and we all do. Sometimes, in situations, a parent does things that are not appropriate in that situation. Now, I'm not saying that every parent would do what she did, but I'm saying that it is understandable for a parent who believes that their child has been wrongfully accused to be upset about it. Now, that was the wrong way to do it, but Mr. James agreed with that. And that's important for the court to understand, is because he was not, Mr. James is not a shill for her. He loves her, but he's not a shill for her. And he agreed with that. And he was honest about his opinion and about his thoughts about that. And now you connect that to what Mr. James said about going into Mark Garcia and going in and talking to him and saying, look, this is the thing. And I asked him, did it feel to you like Mark Garcia was going to do whatever he wanted to do? And he said, yes. Yes, he wasn't going to listen to anybody. And he goes back to your concerns. I understand that there are concerns about that. Of course there are. She was wrong. She was mistaken. She was not malicious in that sense. She believed Mark Garcia. She was wrong about it, obviously. They're going to play you. They're going to play you and show you again, look how much hubris she has. And I will just say to the court, the proper statement is, look how much she had. She's been humbled. She's been humiliated. She has been. She's been pilloried. She's been put in chains. She's been marched down the hall in front of these cameras. All of these things have happened to her. And now she is in a situation, for the final thing that I want you to consider, now she is in a situation where she has picked up her life. She has a business. She employs people that were homeless. She raises her children. She homeschools a child. And I'll just tell you this. I was not going to bring an 8-year-old to say that mommy homeschools me. I know that they tried to cast doubt on that. Her employee did not understand this, her child's education situation. He understands what he does. I wasn't going to bring an 8-year-old to do it because this has gone on long enough. And I'm not going to bring that child in here. But I'm telling you, she homeschools her child. She is responsible for her child's education. She has a young child who is 8 years old. She has been humiliated. She has been humbled. The purpose of this system is to say, who are you now, not who were you then. And who are you now is somebody who will follow your orders, as she has. Anytime you have given her one, she will follow it. She will do well on probation. You can see from her PSI that she has no issues with probation or anything else. She is not in a position of authority. She has been kicked out of her office for her hubris. She's been kicked out of her office because they wanted her gone, and she's gone. She has now been convicted. And we're asking that you allow her to continue with the life that she has built now, outside of the media's eye, outside of all this other things. Allow her to be back with her family. Allow her to continue to do the good that she is doing now. Law enforcement, constable, that was not the position for her. It's obvious. But that does not mean that she should go to prison for this. And so we are asking the court to please allow her to be on probation, to grant her probation, and to grant her the ability to continue to be the mother, to be the boss, to be the friend, to be the sister-in-law that she has been. because there is another side to her that no one has been willing to see. But we have presented part of that side, and we ask you to consider that when considering what the appropriate sentence would be.
Mr. Salinas, I think this built all the way into 44 minutes, so if you want 44 minutes, you have it.
Oh, thank you, Judge. I'm just making sure my technology works, so that's okay. May it please the court, opposing counsel. So, yes, conveniently, she backed her captain in the arrest of Leo Moreno. Why? Because Leo Moreno was her political opponent, one. Second, Leo Moreno also filed a complaint against her. And so, of course, she was going to back him. Why? Because she wanted him arrested. And the court pointed out correctly that even after the case is dismissed, in May, she's still advocating for an arrest of Leo Moreno. And later in the presentation, we'll also see that subsequent to that, even in September, while FBI and the Texas Rangers are raiding the constable precinct's office, she's still advocating that Leo Moreno should be arrested. And this is after she knows all the facts and circumstances surrounding the arrest. She's also the complainant in that arrest. I have the words public corruption and Michelle Barrientes up there. This was a public corruption trial. We presented evidence of public corruption. We presented evidence of public corruption within the punishment phase. Those words are now synonymous. What was she convicted of? She was convicted of 2 felonies. The evidence in those cases proved that she abused her power as an elected official, she violated the trust given to her as an elected official, and her actions throughout the trial, we can kind of get a glimpse into her state of mind. Her reactions to when the grand jury summons are issued are what? Designate others as custodians, not submit a business records affidavit when the grand jury summons is specifically addressed to her. She goes about writing up employees. She's telling Susan she needs a lawyer. Again, all done in order to shield herself or kind of take a step back from any sort of accountability. And the argument of, well, she made 7 copies and all that, and but again, the only person that knows what was actually turned over is her. So when she takes 1 copy and she takes out the documents that she knows are incriminating for her or bad for her that she doesn't want turned over, the only person who knows that she took them out is her. So she's not going to go around taking out all the documents. So we knew a lot of things, or at least we found out about a lot of things within the trial, but centrally we don't know where's the money. So we found out that the office actually took cash payments for Rodriguez Park Security. We know that the defendant was the person who received that cash. We know that reserve deputies worked that park and were not paid. So
Can I stop you right there?
Yes.
Yesterday when the auditor was here, I asked him if that practice is still going on, and he said yes, but they have not changed that.
Actually, I've been informed that after this case came to light, all of the security is handled through the county parks now. There's no longer any of this walking into the precincts and paying money for security. Everything runs through the county. The HR people put into place the contracts, like when they did it for that one day on Easter Sunday for the general security. They've now put in those contracts in place so they don't have to worry about violating the Security Guard Act. And so that all has been revamped, and cash is not taken in that manner anymore. It flows through the county auditor system, and that's how everyone is being paid now.
Well, that's just counsel testifying. The testimony the court heard is the testimony that the court heard. So
Well, I specifically asked if there was any other county office that allowed county employees to take in cash from the public, and then same employees give out cash to other employees. And I believe he answered the affirmative. So that was my only concern.
Well, and during the trial, we wanted to elicit that testimony from parks people about how things had changed and how it is today, but we weren't permitted to get into that because it wasn't relevant to what happened at the time of the offense.
Okay, go ahead, Mr.
So the
Miller.
defendant knew what she was doing, and again, it's her objective to have that concealed.
But there was evidence that this practice was going on even before her, and in other constable offices as well.
That's correct, yes.
Go ahead.
Oh, and my little graphic is not showing, Judge, for some reason. That's weird. So the defendant is dishonest, and I'll point to defense exhibit 10, which was, if I could find it, Your Honor. I don't know why my graphic didn't show.
You can show it to me on your laptop.
Oh, okay. So, Defense Exhibit 10 was after Easter.
Yes, I
You
remember.
recall Defense Exhibit 10. Okay, so that shows the defendant's dishonesty and her lying about simple things. Again, that's a government record that in that document is not true. And how do we know it's not true? Because the defendant's own statement subsequent to that, in her interview with Matthew Seedorf, says that Jesus Reyes had paid $150 to each her and her chief deputy, Castillo. But again, we also elicit testimony that she wasn't even the person that worked the pavilion, that it was the other deputies that did. So again, all these contradictory statements which go to show she's a dishonest person. She's not truthful. And again, going back to the Matthew Seedorf interview,
Are you saying she's the only dishonest person in that precinct? She's
No.
the only one that had, I mean, are you saying anybody else at that precinct had clean hands coming into this prosecution? What about the evidence of people submitting TCO reports that were not truthful?
We didn't bring those witnesses.
There was a witness.
You're talking about De La Cerda and Moreno. We didn't bring them to testify because we know that they were investigated for the TCO incidents and that there was a finding that they were dishonest. So we did not bring them.
Somebody else testified to that.
Well, a lot of people
Minor,
testified.
I believe.
Well, on cross-examination, yes, they did testify to that.
Okay. All
so
right.
I guess to answer the court's question, yes, there are other people who are dishonest within the precinct. Yes, there is one person who is in front of this court who has been convicted of 2 felonies. The defendant's primary concern was not security. The defendant admits that in that Matthew Seedorf interview that the Reyes party suggested that a relative who worked for BCSO could come out and provide security. But the defendant's response was no. So again, picture this in your mind, right? It's really a unique set of circumstances that can only be accomplished by her. And I think that's what's kind of important in this case is that the facts and circumstances are so unique that it takes someone in her position of power, to have been able to have accomplished it. So in this fact scenario, someone shows up, they're having a party, they say, oh, well, we can provide security, it could be a relative. She says, no, you have to pay me. Again, that would, to an average person, that is absurd. It is crazy. The defendant lied about her tires at the search warrant. Again, this goes back to her intent to impede any investigation, to not be cooperative. The Family Dollar intimidation. Her son is accused of a prior shoplifting incident and is told he can't enter the store. So at some point, the defendant decides, I'm going to misuse government resources to settle a personal matter. Again, a fact scenario that is so unique, that is so outside the realm of what a normal person could do. I couldn't do that. It would be like, I guess it would be like the elected district attorney going and summoning every single investigator or a team of investigators to go out to a personal matter. We would think that that was crazy. And that's what she did. She wasn't in danger, and the manager was well within her right to exclude the defendant's son from the store. And instead she said, okay, I'm going to take everybody off traffic so they could come over and just stand in the store while I have a disagreement, have an argument with his manager. Again, that goes to her abuse of power, her abuse of resources, to her public corruption. The execution of warrants. So even after she was instructed to cease and desist, she continued to do so. And there was a statement that she made that she knew the Code of Criminal Procedure better than any lawyer, better than any judge. And we have proof of 93 improperly executed alias and capious profile warrants. So we go back to the arrest of Leo Moreno. Files a EEOC complaint against the defendant. Against the defendant. Leo Moreno is then subsequently arrested for perjury based on statements he made in that complaint. Again, it goes back to, it is a unique set of circumstances that allow her to do this. Very few people could actually get someone arrested. I think about it in my own job, right? For me to get someone arrested, I would have to file a case at large, I would have to go get them indicted, but there's checks and balances along the way. And again, she was able to arrest someone, have someone arrested, that was a person who complained against her and her political opponent. And even after that case is dismissed, she still wants Leo Moreno arrested. And the basis of that arrest is for lying in a complaint that was made against her. And so how do we know she still wants him arrested? The court pointed it out. And of course my graphics aren't showing. Are the text messages that we presented to the court. Of, well, I've dropped off the prosecution package. And, oh, we dropped off the prosecution package with additional evidence. And there's one text message that states, all elements were presented before and again today. So again, it goes into her mind that she believed he should have been arrested back when, in April 30th, and she's again present for the briefing. And then it's still saying, well, he's got to be arrested today. And she knows the reason for that arrest is the statements that he made against me in that EEOC complaint. And then so we go to, while the Rangers, and I'm going to approach the screen to.
That's fine.
While the Rangers and the FBI are executing a search warrant at her employment, at her office, she makes this statement. I'm going to turn up because I don't know how high the media judge.
So apologies if it's super loud.
Leonicio Moreno, he was arrested and then the charges were subsequently dropped. Any thoughts on that?
No, I think that Mr. Joe Gonzalez should rethink, because he seems to think that his beliefs are more important than state law. He needs to go sit back down and look at the state law. Because from my understanding, he is an attorney, so he should be very familiar with the statute. So having read that statute correctly, that warrant was a warrant, the judge signed off on it. That means the elements were met on that warrant. So the judge said, good, it's good to go, we'll sign it, and that's when he was arrested.
I tried calling your personal cell phone. Did they confiscate your personal items?
So again, this is her advocating that her political opponent, that a person who filed an EEOC complaint be arrested, and this is months after it's been dismissed by the district attorney's office, and months after they've dropped off a subsequent file to be filed at large, she's still saying he should be arrested. And that warrant was good. And again, this is all going on while her office is being searched by federal authorities, Texas Rangers, as a result of a search warrant. And we can also see a double standard that she plays, which in this video, I think it's 11:22 right, Don, on the screen?
Yes.
Said I forgot
You know
to.
what? You're saying you have, you know, this is a big show, and the color show, that's exactly what we're doing. Because I understand that the good old system, I understand what the politics. So whether they decide to do, okay, they know what they're getting into, because I know how every avenues are to. But I do have a question for Judge Massimo. My question to him is that why wasn't his son held accountable? Why wasn't this big show done when he was behind? Why was he allowed to walk out the door just like jumping around right out the door? And what are those? What's going on with the alleged accusations of pedophilia with his son right now? That's what I like to know. Is he reflecting those concerns with his son? I heard that. But I think that he also needs to focus on his son's behavior and the alleged accusations, because those are some strong accusations. And as a parent, I definitely want to answer.
Okay. All right. Well, thanks so much, Ms.
So as a law enforcement officer, she would know that this isn't done for some big show. She would know that federal authorities are there Texas Rangers are there. They're executing a search warrant because the court has signed off on it based on probable cause. And also we see the deflection that she does in that she makes an accusation against the son of Judge Wolf, Kevin Wolf, about pedophilia or something like that. Again, all goes to the type of person that she is. That when the walls are closing in, let me blame someone else. Let me go up here and put blame on someone else. Because she can't ever be accountable for what she did. I mentioned this before and a few times, and I'm going to go back to the screen, Jeff. The case is a very unique set of circumstances. And that's what makes it unique. Only someone in her position of authority, in her position of trust, could have accomplished this. The state is asking that you sentence her to prison for 6 years. And I know sentencing someone to prison, asking that someone be sent to prison, is a difficult thing to do. I know that sending someone to prison is a difficult thing to do. But it is the right thing to do for this case in the unique set of circumstances that she herself put her in. Herself. She abused the trust of the people. She abused her office. And it is such a unique set of circumstances that only she could have accomplished. Only someone in a position of power could have done it. And she did it. We ask this court to send that message that this is not okay. What she did was not okay. Her behavior, not only for what she was convicted of, but her behavior within the office, misusing government resources, is not okay. And we ask the court that she be sent to prison for 6 years. Thank you.
Okay, so as I explained yesterday, I'm going to recess for lunch, and everybody meet me back here at 1:30 for the pronouncement of sentence. I am going to lock the courtroom because I do have to view some of the evidence, and I can only use this equipment. So if you have something here that you need during the lunch break, take it with you because I'm locking the doors and I'm not going to open them up until 1:30. So we are in recess until 1:30. Thank you, Lisa.
So, David,
Thank you. You may be seated. Where's probation? Let's go back on the record, please. I do have some preliminary remarks before I impose sentence, so I will ask you to stand at the appropriate time. All right, well, as everyone knows, we're here for sentencing. I received and I accepted the verdict of the jury on the 2 counts of tampering, so we're not here to relitigate that. I'm not going to go behind that verdict. Today is all about sentencing. Since the day that you were convicted, Ms. Barrientes Vela, I have weighed all the evidence in this case. I have thought long about the credibility of some of the witnesses that came forward, and all of that I considered in preparing this punishment. I've heard the arguments of both sides of the attorneys. Thank you both sides for your excellent presentations throughout this whole trial. I read the pre-sentence investigation report. I read the victim statements that came through the pre-sentence investigation report, and I read the results of the TAP evaluation. And in thinking about your punishment, Ms. Barrientes Vela, I have considered the circumstances, the nature of the circumstances. You know, in criminal courts, we hear blood, what I call blood and guts. Blood and guts, sex offenses against children, family violence cases. We hear drug cases, robberies, anything about guns and drugs together, dishonesty cases, and cases of public officials, which is what you're here for today. So what is this case not about? It's not a blood and guts. Nobody was physically injured. There's no child that was hurt. There was nothing egregious about the nature of the circumstances in this case. However, there was a lot of evidence about threats and intimidation and hostile work environment and things that different witnesses described that stem from your elected position. I heard many witnesses refer to you with a lot of contempt in their voice, a lot of disrespect in their voice, and maybe the record didn't capture it for the Court of Appeals, but I heard it, and I considered that in assessing their credibility. I also have to think about the seriousness of the offense, right? And the reason that I have to consider that is because we live in a country that is governed by the rule of law. Laws are important. Respect for the laws are important. And sadly, in this case, that was seriously lacking. Not only by you, but I saw that from some of the witnesses too. In fact, one of them walked away with a dismissal. And so I need to make sure that whatever I issue today continues a pattern of just having respect for the law, because that's the country that we live in. I also have to consider whether I need to protect our community, right? I'm not concerned about that. You are no longer an elected official. You will no longer have, our community will no longer be at risk in that regard. I have to consider your history and your characteristics. You know, it's interesting when anytime that we get to punishment, you know, people want to give judges ideas on what to do, and I don't think they've ever read Section 42A of the Code of Criminal Procedure, and that requires us that we give a sentence with the best interest of justice, the public, and the defendant. So I have to consider your life, your contributions. And I have to say that I liked Richard James yesterday, and I liked your sister-in-law. I liked what they said. I can tell you are loved and respected by your family and supported. And I do believe you have strong ties to your community. I do believe your husband and you have created a business that works for you. So what is available to me as a sentence? Well, straight out prison. Shock probation's available. Straight probation with no jail sanction, and probation with a jail sanction. And today my sentence will be probation with a jail sanction, and this is why. Shortly after Moreno was arrested and released, you gave a press conference, and my concern has been your actions after he was arrested and released. Because in that press conference, in front of the courthouse, you said yourself, I don't answer to nobody. I am the elected official. I am the top boss in the whole office currently right now. Those were your words. And so, as the top boss of Precinct 2, I expected you to tell Garcia that arrest was illegal and call it what it was. So when your attorney tells me today that you simply believed Mark, I don't believe that. I don't buy that. I think that you had the opportunity to distance yourself from that as the top boss and tell Mark Garcia that is wrong. And so you had this awareness of the illegal conduct, and instead of doing something about it, you continued to avoid it and instead persisted that he get prosecuted. And you did so in uniform in front of our county courthouse with supporters with signs trashing our elected officials, our county leadership. So if citizen Michelle Barrientes Vela wants to do that out of uniform and trash the county leadership, that is citizen Michelle Barrientes Vela's constitutional right. But you were in uniform with your entire command staff. And so that does not show me as the judge that you had good intentions with regards to the illegal arrest of Moreno. That shows me the opposite. So the sanction that I'm going to issue will be as follows. If you could please stand so that we can proceed to sentencing. Mr. Goss, is there any legal reason we cannot proceed to sentencing?
No, Your Honor.
It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice, the Institutional Division. That will be suspended. You will be placed on 5 years probation. There's a $2,500 fine.
Fuck the DA! Fuck the DA!
Close the door.
I did not hear.
I'm going to start over. Okay, I don't want anyone else to come in, so please don't let anyone else in. Okay, I will continue. I will start over. It is the judgment of the court that you be sentenced to 6 years confinement in the Texas Department of Criminal Justice Institutional Division. That will be suspended. You will be placed on probation for 5 years. There's a $2,500 fine plus court costs. No restitution is ordered in this case. You will be ordered to satisfy 600 hours of community service. 1/2 of those hours I will allow you to buy out by contributing to the San Antonio Food Bank at $10 per hour. The remaining 300 hours you will satisfy by working for Habitat for Humanity at a location I will designate. There is to be a no contact order with Leonicio Moreno, no contact order with Anthony De La Cerda. I am ordering a $50 contribution to Crime Stoppers. I'm also ordering a moral recognition therapy course. You will complete that course. I will be satisfied if you buy the workbook yourself. I'm not going to require you to go to the group therapy sessions. Confinement, As a condition of your probation, 90 days confinement in the Bexar County Jail. I am going to hold that in abeyance until the results of the appeals are exhausted, but I am ordering it, I'm imposing it once all of that is finalized, and I will decide how you will serve that confinement. I have options. Ms. Barrientes Vela, this is a plea bargain case. I'm sorry, this is not a plea bargain case. This is a trial case. You have the right to appeal both the judgment of conviction by the jury and the judgment of punishment. Lastly, your probation starts today, ma'am. Look at me. Your probation starts today. You have certain appellate rights with regards to a motion for new trial, a notice of appeal, and until I receive in this court a notice of appeal and a request to not go forward with your probation conditions because your appeal is pending, you are on probation as far as I'm concerned, and you're required to comply. And it is up to you if while your appeal is pending, if you want to continue with your conditions. If you don't want to, the law says you can stop, but you will resume as soon as that mandate returns. If everything is affirmed, you start off where you left off. But for purposes of today, you start your probation with me today. I don't have to tell you, I take probation very seriously. I don't mess around with probationers. No reports from you are the excellent reports I want to hear. That you have been a model probationer is what I want to know. I want you to have a seat. You have to sign your conditions of probation, and I will give you the trial court certification of notice to appeal. Now, this is how we're going to evacuate the building. I need to make sure the hallway is secure, and if not, if Mr. DA, if you can go through the back, probably a better.
Your Honor, and we do have a notice of appeal that we would like to tender to the court at this time. We do understand, and I will communicate with our appellate counsel, that you also want an intent, further intent about what they plan to do or what he is advising should happen. Since after this point we're going to ask for a motion to withdraw, Mr. Gross will be her counsel for appeal, and he will be communicating with the court.
I would hold off until her appellate counsel files that. I would file that today if I were you.
He asked me to file it today.
I understand, but there's other things that he needs to come and talk to me about before that notice of appeal.
I understand.
The motion for new trial is due first within the first 30 days of my plenary power.
Yes, Your Honor.
You have the right to file a notice of appeal within 90 days of today if you file a motion for new trial.
Yes, Your Honor.
So if you file that notice of appeal, you're going to cut yourself some time off significantly.
Yes, Your Honor.
So please consult with appellate counsel before you do that.
Yes, Your Honor.
That is all I have this afternoon. We are in recess. Don, you're not going to give me the assistance today, right? I'm not going to sit in trial.
Yeah, Judge, we got to do
Take
it.
it up.
Thank you.